Hello. Hello, everyone, and welcome to our webinar about the key considerations and requirements for industrial designs and copyright in Myanmar. I am Nico, an associate at Taliki and Gibbons, Myanmar. Thank you for joining us today to explore the registration requirements of industrial design and copyright. Our presentation is divided into two parts as industrial design and copyright. For industrial design, I will present in for copyright matter. My colleague, Mrs. Kim Yun-Wee, will share the information. As for the contents, in our presentation, we will provide the overview and key points of industrial design law and rules, requirements, and essential notes of registering and industrial design, and the information about the implementation of the new copyright law and protection of copyrights and related rights. Then let's start my industrial design part. First of all, I would like to give you an overview of industrial design law and rules. On January 13, 2019, Beyonce enacted the Myanmar Industrial Design Law. On October 18, 2023, the enforcement date of industrial design law was announced. Also, the rules are issued by Ministries of Commerce on September 19, 2023, and the official forms and fees for registrations of industrial design were announced by the Ministry of Commerce on October 29, and industrial design law and rules entered into force October 31, 2023. Next, I will provide the definition of industrial design. In section 2G of the law, the definition of industrial design were provided as the appearance of the whole or a part of any industrial or handicraft products resulting from the features of the lines, counters, colors, shapes, texture, or material of the said product itself and or its ornamentations. Then I will go on what are the product-driven design and non-product-driven design. In section 13, 14, and 15 of the law, the requirements for product-driven design are provided. As for the law, any new and independently created industrial design shall be protected in the design or can be determined as new if it has not been disclosed by writing, by publishing, by using, displaying, or any other way in the before the filing date or date of priority for claiming priority. As for the non-product design, in section 16 of the law, if the design is being detected essentially by technical or functional considerations and being contrary to public order, morality, faith, or cherished culture of the state cannot be protectable under the law. So moving on the next point, we see person entitled to file an industrial design. The creators, legal successor, entitled legal transferee, entitled to find the industrial design for the design created by the course of or as consequence of employment contract. For that industrial design, if not contrary to the contract, or if within 1 year after the employment contract expires, that design is created by the employee within the work scope of the previous employer and not in conflict with the employment contract, the employer will entitled to file their designs. However, if the employer has failed to file the application within 6 months from the date of creation, and if the design is not under the assignment of the employer has the right to file the industrial design. These are provided in section 17, 18, and 19 of the law. As for the next slide, the information on exclusive rights are provided. According to Section 46, the register and design owner has exclusive right to prevent a third party from making, selling, or importing products that bear or embody a copy of the registered design, and the register owner has the right to file litigation against the infringer in a civil action, also has the right to assigning or licensing the rights of the registered design. So as a critical point, I will share the registration process. The applicant if the applicant has complete the filing particulars and required documents, the IBD examiner will examine after the submission of the application based on the formality requirements, and the examiner will refuse, or if the application if the formality requirements not comply, or the application are not comply with the law, the examiner will refuse. And if any additional documents or informations are required, the examiner will request that documents by that information by issuing notification to applicant. For such amendment, required documents must be filed within 30 days, and for failure to do, the application shall be considered as withdrawn or abandoned. But the applicant has still the right to request for this failure within 60 days from the date of abandonment. Upon the submission or response with amendment, and the application will be published. As the application is published, any person may oppose within 60 days from the date of application. The examiner will examine the opposition. Based on that opposition process, the industrial design may grant the registration or refuse, and any person may appeal to agency if they dissatisfied with the examiner decision within 60 days. And within 90 days, any person may file a case if agency decision is not satisfactory. The term of registration is 5 years, and the renewal may be done by not more than 2 consecutive periods of 5 years. Then I will go on to the deferment of the publication or industrial design application. According to Section 36 and 37, the applicant may request to defer the publication of industrial design by describing the period of deferment in the application, but the period must not exceed 18 months from the filing date, and it can be withdrawn at any time. As for the next, we'll see the priority claim. Priority can be enjoyed within 6 months from the date of filing in any member country of Paris Convention or any other World Trade Organization member state. Currently, Myanmar is not yet Paris Convention member. The relevant priority document must be submitted within 3 months from the filing date, and for non-language English language documents, credible Myanmar or English translation must be submitted. Any other credible documents or credible evidence can also be submitted if any. Then I will go on to highlight for invalidation and cancellation. According to the Section 59, if any registered industrial design contrary to the grounds for invalidation cancellation provided in the law, any relevant interested persons or legal entity may apply for invalidation or cancellation of the whole parts industrial design registration. About the grounds for invalidation or cancellation, These are described in section 60 and 61 of the law. That if a design falls under section 16, that is a non-productive design. As I mentioned in slide number 6, and the design does not meet the definition of industrial design law, lacks novelty, and the sufficient ground appears for evidence that the applicant is not entitled to file the application, and the registration of industrial design was obtained by fraud, mispresentation, or concealment of any prescribed fact. For the grounds of cancellation, if a design is not renewed within grace period 6 months after expiry of the registration of design, and then it is surrendered to the owner enforced under any fact leading to invalidation as mentioned previously. In slide number 13, I will provide the recordation of assignments and license. Any registered industrial design can be assigned or licensed to any individual legal entity, and it is enforced once recorded with the IPT after providing the applicable fees. Moving on to the next session, I'll provide the requirements and essential notes for registering the industrial design. The application can be filed by online through a local representative or at the receiving counter of the Intellectual Property Department, its branch office in person or by post. For minimum required information to apply or industrial design, that we require ID1 file for application of registration, applicant name, address, and information of creators, such as name, nationality, and address. And then also Myanmar adopts Locarno classification, Locarno classification, ASAP classification for the product associated with the industrial design, the photograph, draw, or graphic presentation of the design, in indication of product described in Locarno classification, written description, number of industrial design, and the period for deferment for publication if applicable, then claiming priority if the applicant wants to claim. Next slide, our focus on the important information of appointing representatives with ID2 form. So any applicant, opposer, right holder, any interested party not incorporated or resident in Myanmar must appoint a local representative by ID2 form. Notarization is required, and the notarization must be done where the applicant is incorporated or applicant resident country. Representative must be Myanmar citizens or business must be in Myanmar. And then we require only scanned copy for filing status, and the original must be provided within 30 days from the date of notification. That is required for only notification matter. As for the last point of mine, I would like to provide essential notes of registering and industrial design. The multiple design cannot be submitted in a single application through e-filing system of IPT. And the detailed descriptions of designs are not a mandatory requirement, but it is required to be mentioned in the application. The words, phrase, or number included in apply for design is the main feature for design. That part will be disclaimed in the description of design. If not, it will be removed from the applied design. Perspective view must be provided because IPT will publish only perspective view of the design in the publication. For claiming the deferment, the request for deferment application or deferment publication must be submitted with Form A with the application form, and the request for deferment needs to be mentioned in the notes. The request for priority claim, Form B, or the request for exhibition priority claim, Form C, must be submitted with the application form. And if not, it will be assumed that the priority is not claimed. So now I will hand over to Ms. Nyo, who will explore the copyright matter.
Thank you, Nico. Hello, everyone. Now we are going to continue presenting about the new implementation of the copyright law in Myanmar. This is to show the history of how the new copyright system has been emerged in Myanmar. Firstly, the new copyright law has been enacted in 2019. Then, in 2023, the relevant officials issued announcement of the enforcement of the copyright law and copyright rule. In 2023, the new copyright law was entered into force. On February 9, 2024, Myanmar IP Intellectual Property Department accepts the copyright applications. Now we are going to share about what has changed. Previously, Myanmar had old Copyright Act of 1914, but it has now already been repealed by the new law. Under the old Copyright Act, it protects only for the work if the work is first published in Myanmar or if the work is created in Myanmar by a citizen or resident of Myanmar. But the new copyright law of 2019 protects the foreign works which has been created by non-citizen or non-residents. This is one of the major changes under the new copyright law. In addition, there is a substantive registration system and enforcement procedure under the new copyright law. Previously, there is no substantive registration process and enforcement can be done under the common practice in Myanmar. Here, we would like you to note that Myanmar is not a member of the Berne Convention, which offers the same protection for the literary and artistic work for member countries. So, even though registration of the copyright is not mandatory, if you would like to obtain the sufficient evidence of your work, you need to apply for your work with Myanmar IP Department under the new copyright law here. Now we will move to the protection of copyrights and related rights under the new law. So literary and artistic work, performance, phonograms, and broadcast can be applied under the new copyright law of 2019. This is to show the protectable works under the new law. For the literary and artistic work, the work must be first published in Myanmar or published in Myanmar within 30 days of the first publication in any other country if the work is created by a non-citizen or non-resident. This is especially related to the foreign works. Published work or unpublished work of an author who is a national or resident of Myanmar. Audiovisual work or cinematographic work of a producer who has headquarters or resident in Myanmar. Architectural built in Myanmar and artistic work incorporated in a building or other structure in Myanmar. These literary and artistic work are protected under the new copyright law. In addition to the original work, derivative work can also be protected, but it must not affect the original work. The derivative work may include translation, adaptations, arrangement, and other alternation or modification of literary or artistic work, collection of these works and traditional cultural expression, and compilation of data. These derivative work can be protected. For the performance, a performance made by a performer who is a national or resident of Myanmar. If not, the performance by a performer who is not a national or resident of Myanmar, if the performance takes place in Myanmar or the performance included in broadcasting, which is qualified for the protection under the new copyright law, can be protected under the new copyright law. For the phonograms, if it is produced by a national or if it is first fixed in Myanmar, or it is produced by a non-citizens or non-residents if first published in Myanmar or published in Myanmar within 30 days of the first publication in any other country, which related to their foreign phonograms, they can be protected under the new copyright law. For the broadcasting, broadcast by a broadcasting organization whose headquarters are situated in Myanmar, or broadcast transmitted from a transmitter situated in Myanmar, the new copyright law offers the protection for this broadcast work. These are the unprotectable work under the new copyright law. Basically, ideas, procedures, method of operations, discoveries, data, news of the day, press information, laws, constitutions, rules and regulations, government departments, notifications, order, code judgment, these cannot be protected. In addition, government's translation and collection of this information cannot be applied for the copyright. This is about the application process of the copyright under the new copyright law. It's show a bit simple. After you submit an application, the IP department will examine it. If formality requirements are complete, the application will be processed for the registration, then it will be published. If there is any additional requirements during the formality examination stage, the IP department will notify the applicant. Then the applicant needs to comply with the requirement within 30 days. If not, the application will be refused. If the applicant does not satisfy with the decision of the IP department, they are entitled to apply for an appeal with an IP agency within 60 days. Then, if the applicant does not further satisfy with the decision of the IP agency, they have the right to apply for an appeal with the IP code within 90 days. So there is no substantive examination during the application process. The IP department will focus on the formality requirement and supporting documents that will be relevant to the applying work. Yeah, this is the application process. So other copyright and related right owner, performer, phonogram producer, and broadcasting organization can apply for the copyright registration. There are 3 ways to apply for the copyright with Myanmar IP department: by electronically, which is online filing system organized by the IP department, or in person, or by post. You can apply application either in Myanmar or English language. Then the applicant need to appoint its local representative if the applicant is not reside or incorporated in Myanmar. The local representative must have the representative certificate issued by the Myanmar IP department. As we mentioned earlier, the registration is not mandatory for the copyright, but it can be applied voluntarily. These are the terms of economic rights for copyrights. For a literary and artistic work, it is protected for a life of the author plus 50 years. For audiovisual work and films, 50 years from the publication. For performers, 50 years from the year of the performance or fixation in any medium. For broadcasting organization, the work are protected for 20 years from the year of broadcast. For phonogram producer, it is protected for 50 years from the year of publication or fax fixation if it is unpublished work. For work of applied arts, it is protected for 25 years from the making of the work. The moral right of author and performer are valid for perpetuity. In addition, under the new copyright law, the right holder can transfer their economic rights to any individual or legal entity. Under 5(b), they are inherited under any existing law or customary practice, transfer by testament, gift, donation, transfer of ownership, and/or any existing law of Myanmar, or by way of assignment. The whole or some part of right owner's economic rights can be transferred. A registered copyright or related rights can be cancelled by any individual or legal entity based on the publication of the IB department. If any individual or legal entity would like to apply for the cancellation of registered copyrights, the ground may include the registered copyright or related right is unprotectable work under the copyright law of 2019, or the other copyright owner related right owner is not entitled to the registration of the work, or the registration certificate has been obtained by an inappropriate way. Now we will share with about copyright enforcement. These are the prohibitions under the copyright law. Reproduction, communication, or distribution to the public of protected copyright or related rights directly or indirectly, possessing or trading infringed copyright or related right goods, importing infringed copyright or related right goods into Myanmar, possessing essential materials used in making infringed copyright or related right goods. These actions are prohibited under a new copyright law. If anyone violates the prohibition, the maximum imprisonment would be up to 3 years or fine up to 1 million kyats or both. And there is a maximum imprisonment up to 10 years or fine up to 10 million kyats or both if anyone committed again after the completed one of the prohibition. The copyright dispute can be resolved by 3 ways, which is offered by the new copyright law, which are consultation, by arbitration, or by judicial proceeding under a civil or criminal action. So for any dispute, we need to consider the case background and specific circumstances to consider the best option for the right owner benefits. For the cross-border measure, the right owner can apply a copyright recordation, custom recordation of copyrights with Myanmar Customs Department. For doing so, the registration certificate is one of the mandatory requirements. Even though the registration for the copyright is not mandatory, but if you consider for the custom recordation, the registration certificate is mandatory. For the time being, the Customs Department is still finalizing the custom rules for the detailed procedure about the custom recordation. So we need to wait for the detailed process, including the fees for the custom recordation under the new copyright law. So this is end of our presentation, and thank you for your attention and time. If you have any question, please feel free to send to the chat box, then we will address for you.